Queensland developers frequently use subsidiary companies, special purpose vehicles, to isolate risk on individual projects. In theory, the corporate veil protects the parent company, but that protection is not absolute. When a subsidiary faces insolvency, the holding company itself may, in some circumstances, be liable for the subsidiary's debts. Here are 4 things every director needs to understand. First, a holding company may be liable for a subsidiary's debts if there were reasonable grounds for suspecting the subsidiary's insolvency, and the holding company, or one or more of its directors, was aware of those grounds, or it was reasonable to expect that awareness. That is why active oversight matters. The issue is not just what someone says they actually knew. The law also looks at what ought to have been recognized, having regard to the information available and the holding company's level of control. If management accounts, aged creditor reports, cash flow forecasts, or unpaid statutory liabilities contain warning signs, passive ignorance is unlikely to assist. Second, the Corporations Act provides 4 key statutory defences for holding companies through Section 588X, and each one rewards diligence. Broadly speaking, those defences focus on reasonable grounds for expecting solvency, reasonable reliance on a competent and reliable person, genuine non-participation in management for good reason, or taking all reasonable steps to prevent the debt being incurred. The common thread is active, informed, and responsible conduct. Third, the Safe Harbour regime provides a separate form of protection where directors are actively developing a course of action reasonably likely to lead to a better outcome than immediate administration or liquidation. For directors, the key provision is Section 588GA, and for holding companies there is parallel protection under Section 588WA. But Safe Harbour is not automatic. It depends on genuine restructuring steps, attention to core obligations, and a real plan supported by appropriate advice. And fourth, meticulous, contemporaneous documentation is critical to supporting any of these defences. Board minutes should do more than record resolutions. They should show what financial information was reviewed, what questions were asked, what advice was received, and why decisions were made. Combined with regular reporting, including management accounts, updated cash flow projections, and aged creditor and debtor reports, that paper trail may become important evidence if the position is later challenged. The Corporations Act is directed to passivity, disengagement, and the failure to respond appropriately to clear warning signs. Those best placed to rely on the available protections are those who stay engaged, ask the hard questions, and keep the records to prove it. If you have not reviewed your governance processes recently, now is the time.